Good morning, all. This hearing is in the matter of CFI 015-2025 and is being held by way of video conferencing before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Mason Partners UK LLP. Lead counsel is Mr. Rumen Cholakov. The defendant is self-representing. Thank you, Your Excellency.
All right. Now, I think it's Mr. Makeda, is it? Representing
Correct.
the...
Yes.
Yes. Well, Mr. Makeda, this is your application. What do you want to say in support of it?
Your Honor, good morning. The only thing that we want to ask the court, that we had been working a little bit with Waldorf in the last 2 days, is to give us a proper exit plan so we can follow all the court orders. We don't want to make any other appeal, nothing at all. We just want to get exit in a proper way, but allowing us in a humanly manner to have working hours, access, elevators, everything that is needed for my team that has been denied in the last 2 weeks, and for the third-party contractors that we already approached and they are ready to go. But until we have all these conditions met, they will start working.
Well, the major differences between you seem to be these. First, how long you should have to remove your assets from the premises.
Correct.
Now, you want until the end of August, effectively. Well, why is it going to? That seems an extraordinarily long amount of time to remove your assets from the premises. Well, why will it take that long?
Well, at first, Your Honor, we didn't want to reach at this point because we could been working already in this for the last 2 weeks, no, and we had been already in an ongoing work from our side, but has been denied from the other side. All the contractors that we approach, all of them, they ask at least 15 working days for dismantling, packaging, and get everything removed.
Did you say 15 working days?
At least 15 working days, yes. So I am totally transparent, and always we were transparent with Waldorf. We provide these numbers. They rejected, obviously. But I think even they, in the last days, they approached to some other contractors to see if this is true or not. And I am totally honest. We approach a lot of people. We're trying with the people that is giving us the least amount of time from their side. Just one company right now that we approach, they gave us 12 days for packing, only for packing, but at the same time, we can start working with dismantling and everything, so we can speed up the process. We don't want to delay from our side. We want to make it as soon as possible so we can deliver the venue and we don't have any issues with Waldorf. But with those restrictions implemented, with no access to elevators, with no access to the inside of the venue for workers, for the bathroom, water.
All right, we'll come to that. We'll come to all that, because that seems, well, it doesn't seem to me that there's any real argument about that anymore. The claimant has put in a draft order in which they propose that you have access between certain hours, and we'll come back to that. But they propose that they shall allow you to use the service elevators and loading bays to the property. Exactly. So that doesn't appear to be an issue. So the things we've got are the length of time and the hours. Is 9 a.m. till what do they propose? 9 a.m. to 6 p.m. Is that a problem?
No, for my side, no. And maybe if we can, some of the contractors, they ask us to start maybe at 8 a.m. I don't think that will be any issue with Waldorf. So they can start maybe a little bit earlier, so they can speed up the process. Because sometimes for them it's more challenging after 4 or 5 p.m. for logistics and all of that. So maybe from 8 to 5, 8 to 6 will be better. All
right. And then, all right. Those are the major issues, it seems to me. If I look at, Dr. Makeda, do you have a copy of the draft order that was sent through by the claimant?
Yes. Order. Yes, I have it here.
All right, but if you go to paragraph 3,
Yes.
they say from 28 July until 15 August, the claimant shall provide the defendant with access to the property from 9 a.m. till 6 p.m,
Correct.
Monday to Friday, and so on. Now, first of all, well, that is 15 working days.
Yeah.
So that should be sufficient, shouldn't it?
Yeah, I hope the best, Mr. Your Honor.
Yeah.
It will be not in my hands. I will speed up with the contractors so we
right.
can make it as soon as possible. And in my last email that I sent to the lawyers and also the registry, if for any reason the contractors still need a little bit of more time, we will be able to communicate this to the landlord if we require maybe a couple of days more or something like that. Obviously, we will try to, from our side,
Yeah.
to be totally in the schedule and provide how to say, weekly notifications how is working done and how the progress is done right now.
All right. Then further on in their order, they say that the claimant shall allow the defendant to use the service elevators and loading bays. So
Yeah,
that's
finally.
okay.
Yeah, thank you.
Next, the claimant shall allow the defendant to use the restrooms, water, fridges, and other facilities.
Yeah.
So that's okay.
Yeah, thank you.
Then they want the claimant shall be entitled to supervise the defendant's access at its discretion. I'll speak to Mr. Cholikov, but I'm not sure that the words at its discretion are terribly helpful. And I would have thought supervise means and should be qualified perhaps
Exactly.
by reasonably supervise. Do you have a problem with that?
No, Your Honor, nothing.
Okay.
We just want to make it happen.
And then their next point is claimant shall bear no responsibility for payment of the electricity expenses relating to the property which remain due and outstanding to DEWA. And for the avoidance of any doubt, the claimant shall not be responsible for providing electricity to the property for the defendant during these times.
Yeah,
Do you have
we need the electricity. No issues at all.
No issues with that.
Yeah.
All right. Now, well, the other matters that I would add,
Yes.
in your order, you asked for an order that the order be supervised by the court. That's not something the court ordinarily does in those terms, but what is the usual practice, which I may follow, is to provide that you have liberty to apply. So what that means is if there's a problem in working out the orders, a problem between you and the claimant, then you can come back to the court to seek some more orders. So that's the way I would deal with that. As to allowing extra time, as I say, that would be a matter which would be dealt with in this way. In the first instance, of course, you must use every effort to get it done within the time that's allowed to you. If then failing that, you could then use your liberty to apply to the court if there was a problem. But I would expect, having got this far now and where it seems the parties are coming together about how this should be done, I would expect that some common sense would prevail. If you've used reasonable efforts and another few days are required, then you would tell the hotel, you would tell them why, what's going on, when it'll be done, and so on, and speak to them reasonably. I would expect that that could be sorted out between you. If not, then you'd have to come back to the court. So on that basis, is there anything further you would want beyond what's set out in the claimant's order?
Well, at the moment, nothing else, Your Honor.
No.
They agree on our terms, obviously, because the hearing was scheduled.
Yeah.
Sadly, that we needed these procedures to make it happen. But yeah,
All right.
thank
Well,
you.
I'm going to go to Mr. Cholikov now. Mr. Cholikov, the first matter is your paragraph 3 of your order, that the amount of time 15th of August, well, with one qualification that gives the days which probably the minimum time that the defendant requires. Now, I see you say Monday to Friday. There's a reference, the defendant referred to Saturday morning. Is that a problem for the hotel?
Your Honor, my understanding is that Monday to Friday, because of the supervision that is required, and my instructions are that reasonably is of course entirely appropriate. We're happy with reasonable supervision, but there needs to be some supervision given the history of the forcible re-entry of this property by the defendant. And that is why the claimant is keen to be able to oversee what is going on. And Saturday is not a working day. What we are happy to offer is 8 in the morning, as requested. I have instructions that it can be 8 a.m. until 6 p.m. Monday to Friday.
Okay. All right. Then, as I've said, your subparagraph C should read, the claimant shall be entitled to reasonably supervise the defendant's access. Then, in relation to your paragraph D, I think that seems reasonable, except I would strike out the words "and must be settled by the defendant," because that might be ambiguous. It might give rise to an understanding that it's an order that the defendant must do that, whereas I'm sure your intent is simply, if they want the electricity, they have to arrange to connect it.
Yes.
All right. I would then also add in as a liberty to apply provision, that the parties have liberty to apply to the court on, say, 24 hours notice to the other party for further orders or directions in relation to the implementation or enforcement of this order, including but not limited to any issues arising from access to the property, compliance with the vacating conditions, or any other matter relevant to the delivery of vacant possession. Are there any other matters that you see need dealing with, Mr. Cholikov?
Your Honor, just on the last paragraph, we don't oppose it. It would be helpful if we have longer notice if there were that application. Obviously, they've got until the 15th of August. They have not, over the past few weeks, taken advantage of opportunity of access having been provided. And that is, in my client's, what is on their instructions. Obviously, we don't have a bundle, unfortunately, but I could have otherwise shown you some emails. But that is the reason why nothing's really progressed. And in my client's eyes, access has been provided.
Yeah,
nothing that has not been utilized.
We're talking about liberty to apply. So it's a matter of how much notice each party must give to the other if they're going to make an application. And I proposed 24 hours. I would have thought it's in everybody's interest that if some dispute comes up, that it gets dealt with pretty quickly. I'm assuming your client wants them out of the premises and wants the premises cleared out and you can get on with it.
No, most certainly.
Yes.
I see where your Honor is thinking. What I was hoping to avoid is an application on the 14th of August to be listed on urgent basis on the 15th of August. But if that's what we need to do, then of course we will, and then we'll be available.
All right. I think that probably deals with the matters. Now, there are two other matters, Mr. Cholikov. The first is that your order provides first that the application is dismissed. I don't want to get into too much about form over substance, but the point is that I propose to make orders, and given that I'm going to make orders, it's not appropriate that I both dismiss the application and make orders. So I propose to not dismiss the application, but simply to make the orders from paragraph 3 of your minute with the changes that I've indicated and the liberty to apply provision. The next point is the question of costs. I'll allow both of you to speak, but I'm going to tell you the view that I have formed is this, that whilst each of you blames the other for and of course I'm referring to your client, Mr. Cholikov, not you, of course, whilst each of you blames the other for what has occurred, on my appreciation of the papers that have been filed and what has been said, both parties have contributed to the position we're now in, and it's reasonably necessary to make the orders that I'm going to make. Accordingly, my current view is that there should be no order as to costs. Now, I'm not shutting you out, but you're going to have to, you're pushing against, you got a task if you want to persuade me otherwise. Do either of you want to persuade me otherwise, Dr. Makeda?
Thank you. No, I think your point of view is acceptable and with a bigger scope.
Thank you, Mr. Cholikov.
Thank you.
May I just turn my virtual back for 5 seconds?
Yes.
We're content with that, Your Honour. No orders to costs is acceptable.
Thank you very much. All right. Well, I do consider that I should make these orders. I consider I've got power to make the orders under Rule 25. I consider it's appropriate to make these orders because no orders were made when the orders were made on the 15th of July in relation to the removal of the defendant's assets from the premises. The parties have been unable to deal with that matter without the assistance of the court. It's therefore necessary and it's prudent and appropriate for the court to make the orders. I will therefore make orders in terms of paragraph 3 of the claimant's minute with the following changes. In the time for access will be 8 a.m. until 6 p.m. In paragraph C, I will insert the word reasonably before the word supervise and delete the words at its discretion. In paragraph D, I will delete the words and must be settled by the defendant, and there will be a further order for liberty to apply in the terms that I indicated earlier. And there will be an order that there be no order as to costs. All right, is there anything further for today?
Nothing else. Thanks for your help, Your Honour.
Mr. Cholikov. And I'm sure both now Mr. Makeda and Mr. Cholikov, I'm sure your clients are listening. And I know each party sees that the other party is causing the problem and the difficulty. But can I please urge everybody to be as cooperative as they can? And that means at times giving some ground, because that is going to be the most sensible and cost-effective way for you all to resolve this matter without more delay and possibly the unwanted further intervention of the court and the costs and inconvenience that goes with that. So I congratulate you for having reached the accommodation that you have and urge you to continue to cooperate so that no further intervention by the court will be necessary. So thank you. That completes today's hearing. Thank you.